The following program is a Town of Colonie television production of the William K. Sanford Town Library.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we're truly fortunate to be joined by a premier attorney in the field of intellectual property law. Intellectual property law cuts through a variety of issues facing society today: trademark infringement, patent law issues, domain name issues, even false advertising. Obviously, our time here today could not truly fully explore the length and breadth of the practice of our guest today, but please join me in welcoming David Miranda. David, thank you for joining us today.
My pleasure.
And David, currently you're practicing with the largest intellectual property law firm in upstate New York. Is that correct?
That's correct.
And where is your office?
Our office is based here in Albany. We have 30 attorneys and patent agents. The law firm is Heslin, Rothenberg, Farley, and Mesiti. I'm a partner there. We have offices in Albany and Rochester.
Well, David, it's fantastic to have you here, and I know you graduated from Albany Law School just a year or two after I did, and obviously involved in a very significant part of our legal community today, intellectual property law. Where do we begin? Domain names, false advertising, patent law issues. Tell us briefly about the nature of the practice that you do.
Well, intellectual property law focuses on a number of different areas: copyright, trademark, patent, trade secrets, false advertising, as you mentioned, licensing, and litigation regarding protecting those areas. Our practice focuses exclusively on intellectual property law. We don't do anything else. So we have a broad base of technical background as well as legal background in our firm that covers a number of different technical areas and industry areas so that their intellectual property can be protected across the board.
David, many times I'll hear citizens say, you know, that was my idea, and someone else has taken my idea, and now they're making money on something that I worked on that was my idea. Do I have any rights? What say you?
I hear that too, and it's very important that individuals who are involved in creating either works of art or written materials or inventions or slogans or trademarks, that they understand up front who owns what, and there's an understanding between the parties, usually preferably in writing, as to who owns what. That will solve a lot of the problems. Oftentimes clients come to us after there's a problem where things seem very rosy right at the beginning, and then there's an issue because there's a difference of opinion as to who owns what.
Well, there's no question that you've gotten yourself into a variety of courts, litigating from here all the way to California in the federal court system, and also working with a variety of arbitration cases as well. I understand that you have served as an arbitrator in connection with infringement allegations regarding McDonald's, Amazon, and others in that way. How do you get involved in that?
Well, I serve as an arbitrator for the National Arbitration Forum, which has a procedure for recovery of domain names where there is an accusation that it's infringing upon a trademark holder. And the advantage of proceeding through arbitration is that a trademark owner is able to recover a domain name that someone else is using improperly very quickly and fairly inexpensively. The cost of litigation in federal courts is very expensive. There's a saying where people say, well, you don't have to make a federal case out of it when you make a big deal out of something. And there's a reason for that, because federal litigation is very expensive.
Well, the arbitration issues must take you across the country from time to time. Is that right?
Well, actually, the arbitration comes to me.
Okay.
I get chosen as the arbitrator, and they would come to us here in Albany. And it's really a wonderful process. They have, I receive the papers and make a determination solely on the issue of domain name and trademark issues.
Well, Albany Law School, in one of our alumni magazines, in a quarterly magazine, did a nice write-up on some of your experiences and some of the great things that you've done on behalf of your clients. And it seems that oftentimes you get involved in protecting the material of an educational institution. Is that correct?
That is correct, and we represent a number of educational institutions, locally certainly, who are increasingly finding the importance of protecting their intellectual property, whether it be copyright in an exam question, whether it be trademark of their logos, or whether it be patents in research and development that they've spent so much time and money developing. And we work on protecting and commercializing those materials. You're right, though, that our practice does take us across the country. It's a federal practice that we have, and we are litigating matters throughout the federal district courts throughout the country.
Well, I understand that the nature of the practice that you work with, that on staff are also a variety of people who are not only very familiar with patenting issues here in the federal system, but also with backgrounds in biochemistry and pharmacology and the like. And why do you need to call on those types of people in connection with your practice?
Well, we talk about intellectual property, and you think usually about, well, high tech and science, of course. And what we have done, because we focus exclusively on intellectual property laws, we divide our firm up of 30 attorneys and patent agents into various industry practices. The attorneys and patent agents that work with us have experience in a variety of technical backgrounds. So if we have a pharmaceutical company that comes to us with a new drug that they're developing, then we send them to our pharmaceutical practice group, and we've got 4 or 5 individuals that have experience, some who worked in research and development, some have doctorates in that area. So they speak their language, their science language, but they also understand the aspects of the law. And so then we have a group in biotech, we have a group in computer science that works on software issues. We have a group that focuses on clean energy and alternative energy, which is a real thriving practice here in our region. And then we have a litigation group where I work.
And you are focused primarily on the litigation part, which is a tremendous effort by you, because you are the one that has to take this very technical information and be able to convert it into language understandable to the court and to the jury that's present as well.
That's absolutely right. And that's really what I think sets our law firm apart, is that we have the individuals that both understand the science background and also understand the courts and can make that transition seamlessly.
David, how did you first, after Albany Law School, how did you transition into your current capacity here?
I started out as a general litigator. I worked for a general practice firm where I did litigation of all sorts. Around the mid-90s, I started working with a lot of internet companies, which brought me into the areas of trademark and copyright. And in 2001, I joined Heslin, Rothenberg, Farley, and Mesiti, where I'm now a partner, to focus on their litigation of intellectual property matters. And it was a good merger of my internet work and my litigation work.
Now, the firm you're with now, were they always focused on intellectual property law, or what are the beginnings of the firm?
Well, the firm was founded by Bob Heslin 38 years ago. He's a patent attorney, and he's started the firm as a sole practitioner, developed a reputation, and over the years we've grown, as I said, now to 30 attorneys and patent agents, which is, as you've noted, the largest purely intellectual property law firm in upstate New York.
Oftentimes citizens become exposed to a variety of issues which may be under your purview. We hear about knockoffs and booters and purses that look like a particular brand, or watches that appear to be a particular brand, even sunglasses that may look like a particular brand. Do you ever get involved in protecting the property right of the original manufacturer?
Yes, we do very much, and it's more and more of an issue as the years go by. You know, the world is getting smaller in many ways. We're more connected, which has advantages and disadvantages. And we're finding that with respect to, for example, manufacturing and cheap labor overseas, that there are knockoffs, and it's becoming, I think, more and more of a problem where something is innovative and the ideas are created, let's say here in the US, and then you're seeing it being knocked off in other countries and then imported into the United States. And it's a problem for bona fide, legitimate manufacturers in the United States. So what we do, we get involved in protecting not only in the US, but also trying to protect our clients' innovations from being imported into the United States. And also, we have a network of foreign affiliates that we work with to protect our clients' intellectual property throughout the world.
How do you go about, if you're trying to protect, say, the purse manufacturer or a sunglass manufacturer, what kind of steps can you take to protect their product?
Well, there's a number of things that you can do. One thing is to have protections not only in the United States, which would be with the United States Patent Office, but would be to also have protection, let's say in the European community or in the Pacific Rim countries, where you might have a considerable market for those materials. That would be one step, that we assist our clients in making sure that they're protected. Another way is to commence litigation within the U.S. to protect and prevent these infringing materials or knockoffs from entering the U.S. border. And there's some various legal means that you can take to notify customs that these materials are knockoffs and that they should be stopped at the border.
And yet, it can be a local issue. There are times people may go to a concert or to the racetrack or to some other event with many people of mass assembly, and there are people selling T-shirts or some other item with the name of maybe the band that's now performing at Saratoga Performing Arts Center, but they had no right to actually use the band's image or likeness, and yet they're out there selling T-shirts that way. Do you ever get involved in trying to stop that kind of action at a local level?
We do. More likely, we're getting involved to stop it on the larger level, to stop the distributorship, because once you cut the supply, then you can stop the sales at the local level. But on occasion, we get involved with law enforcement where we have an order in place that needs to be enforced, and we will work with local law enforcement on enforcing that order. But more likely, our role is to stop the bigger picture, the manufacturers that are producing the knockoffs, and stop the supply from coming in. Because if you don't stop it there, for every one person that you shut down, there's going to be 3 others that pop up to do the same thing. So you have to stop the supply.
Do you ever get involved in the music industry in this way?
We do get involved with the music industry. There's a lot of, that's more on the copyright side of issues, and there's issues pertaining to distribution of music, whether it be digitally, whether it be use of recordings in bars or without proper licenses. So we do get involved in the music industry a little bit.
Well, it's brought you far and wide as well, and I know that there was another case that was well written about concerning a matter involving manufacturing of items in Germany and then distributing those items here in the United States. Does it bring you out? Have you ever had to leave the country to continue to investigate a particular case that you've had?
In that particular case, we represented a consortium of clients who pooled together, and we represented one individual from a client from Germany, a client from Canada, a client and two from the United States. So much of our work involves international applications. That particular case that was before the International Trade Commission in Washington, D.C., after the case was decided, because the case involved both national trade policy and international trade policy, there was a review period where it went before the president, at the time was President Bush, had an opportunity to review the decision, and we had an opportunity to participate in a committee that was formed by the president to study the decision of the International Trade Commission, which was also extremely interesting and kind of a little different aspect for legal practice.
Earlier today, we've touched briefly on internet domain name. Have you had any cases concerning the violation of someone's internet name, or had in any way, which may be of very much interest to our viewers about the internet? Anything in that way that you've
Absolutely. It still continues where there's someone that has a trademark, a mark that they've been using for many years. For whatever reason, they may not have registered the .com. And it turns out that either a competitor or someone else in the industry decides to register their trademark as a domain. And even if they're not selling the particular goods that the trademark owner is selling, they're using that domain to divert internet users to another site, whether it be for gambling or advertising or some other purpose or a competitive purpose. And we get involved in that in recovering the transfer of domains to the rightful trademark owner. And alternatively, if someone has a registration of a domain name that they're using for a bona fide, legitimate business purpose, we also assist those individuals in keeping and protecting the mark and domain that they've created.
Well, in connection with your practice on that field, I understand that you brought the first case before the World Intellectual Property Organization. Tell us about that a little.
I did. It was in the year 2000, and the difficulty with domain names is sometimes you don't know who the registrant is. Sometimes they use aliases, sometimes they're registered in a foreign country, sometimes you can't get jurisdiction over them in U.S. courts even if you wanted to sue them. So in 2000, the International Corporation for Assigned Names and Numbers, which distributes these domain names, developed an arbitration policy so that you could, through an arbitrator, recover a domain even if you couldn't get jurisdiction over the individual. The company that provided the registration of the domain would have to comply with these arbitration decisions. So in January 2000, we commenced the first domain recovery case. It was 2000-001 was our case number, and we recovered the first domain name under these new rules in the United States.
Did you find, was there an opponent in opposition, or did that person who was using it just not even appear before the tribunal, or how did it work?
That was an example of an individual who was trying to stay under the radar.
Okay, all right. Now, where did you have to go to present your case?
Well, the case was presented to the World Intellectual Property Organization, which is based in Europe, but we were assigned an arbitrator and just submitted our papers to the arbitrator, and that's how the arbitration process works. So we didn't have to travel anywhere. It was a very cost-effective, efficient way of recovering a domain name when you've had a hard time really grasping who the particular individual is.
Now, has the organization since entertained many petitions since your first one?
Oh, absolutely.
Yeah.
It continues, and the whole process has really caught on as an alternative to litigation. Sometimes litigation is the way to go because there's damages and There's a lot of legal issues that need to be determined. When it's purely a bad faith registration where someone is taking someone else's mark and there's no question about it, sometimes arbitration is the best way to go because you can get it quickly, sometimes within 60 days, and the cost is much less than federal litigation.
Many citizens often have ideas and concepts of what they think might be a great invention or some other notion that may ultimately be very important for society in general. Any general tips that you can suggest to citizens as to if they're setting out on creating something, what they might want to consider to best protect themselves in the infancy of their ideas?
Well, the first thing I would say is it's always wise to consult with counsel first, rather than after there's a problem, because you can consult with counsel first. It won't be necessarily terribly expensive to put an agreement in place. It's going to be more expensive down the road, certainly, to get yourself out of a situation that you didn't intend to be in that could have been protected by an agreement between the parties right up front. So it's generally, although it's like going to the dentist, I think you don't want to go unless it hurts, you should consult counsel early on.
Right, and many people also try to do everything by themselves up until the point where the roof has now fallen in, and then they seek counsel at that time. And I often suggest to citizens that it's best to, if you really want to take full advantage of counsel, start early with them.
Right.
That's correct.
Because the hardest thing that I see sometimes is that someone comes to me with a legitimate claim, they're on the right side of things, but things have developed to such a point that they're in a difficult position. It's going to cost them a lot of money to get out of it. And knowing that if they had worked this out earlier, that it would be really a savings for both sides. The most important thing when you're getting involved with a third party and protecting intellectual property is that both sides understand fully what the rights are between the parties, and that understanding is memorialized, because what is rosy and supposedly understood at the beginning, if it's not memorialized with a license agreement, let's say, then down the road, people's perceptions of what the understanding was sometimes changes. And it's difficult to go back and redo that.
Well, David, you're involved in so many things on behalf of our community as well, not only spending a significant amount of time litigating intellectual property law issues, but also serving, for instance, as the president of the Albany County Bar Association. And I know that you also have much to do with the state bar as well. How do you see the bar associations emerging as we go forward, and what do you believe the purpose of those associations are in connection with law and society?
I think our bar associations do a wonderful job and are extremely important to providing individuals with an understanding of what the legal process is, to have provide support for access to justice for all throughout New York State and the country, and to speak out on issues where attorneys are uniquely situated to contribute to the dialogue, not on every issue necessarily, but on issues pertaining to selection of judges, again, on providing legal access for the underprivileged. Those are areas that attorneys have a unique point of view and can contribute to the underlying dialogue with respect to it. So the Albany County Bar Association also does a wonderful job. I'm very proud to be serving as its president for this year, of providing, organizing pro bono legal services for family court matters. We have a pro bono divorce clinic to provide programs like our Law Day Run, which is coming up in April, to support victims of domestic violence. So we do a whole host of wonderful programs that support the community and also provides an opportunity for attorneys to be involved in the community.
And you play a role in the New York State Bar Association as well over the years, haven't you?
Yes.
And how does that dovetail into your county bar relationship?
Well, I think there's a lot of overlap. The State Bar does things, but certainly on a bigger scale. I think when you see the New York State Bar Association, they're more involved in lobbying issues and policy issues with the state of New York, whereas the Albany County Bar, I think, is focused more on the Albany legal community, which is good. I serve on the executive committee of the New York State Bar Association. And it provides a lot of substantive programs. It provides a lot of a broader base of community and public interest service.
Well, in connection with that, does the State Bar have its own department that focuses on intellectual property law as well?
Yes, there's an intellectual property law section.
Right.
And there's this very active, progressive group. Attorneys from throughout the state and really from throughout the world are members of the intellectual property section of the New York State Bar Association, which is really a wonderful benefit for me to have these contacts both throughout the state and really throughout the world, so that if there's issues that come up, there's people that I've met that I know that I can either bounce an idea off of or refer a client to or refer a client back over to me.
One of the issues that we spoke about briefly, but I always find very interesting, is the allegation of false advertising. And of course, that can certainly intersect with what your firm does. Can you think of any examples or any former cases that you had that was the sum and substance of the case of an allegation of false advertising?
Well, certainly. False advertising comes into play oftentimes in the trademark context, where there's times where it is not inappropriate necessarily to refer to someone else's mark, let's say for comparison purposes, to say, well, our product is better than such and so's product because of this. That, if it's true, is acceptable. What happens, though, sometimes is that you have individuals that want to piggyback off of someone else's product and are advertising their own services in a way that falsely implies that they are somehow associated with the other product. And that's, it's sometimes can be a gray area, but oftentimes it's very important to a trademark owner to protect the goodwill in their mark and in their products and services. And when someone else falsely represents that they're associated with that mark and that goodwill, it could cause harm to the trademark owner and to the company, and that's when we get involved.
And is the relief sought by the owner of the trademark injunctive relief and potentially monetary damages as well? Is that...
It depends on the situation. You're entitled to equitable relief, which would be injunctive relief, which is you have to get them to stop doing an ad that's false. And you actually, we take the ad and we go through it and we point out the parts that are false and falsely represent issues pertaining to our client or our trademark. And so you get that stop. That's number one usually. The next thing is, if they've made money off of your good name, we'll be there to try to make sure that you get those, the trademark owner gets that money back. Sometimes it's a little bit harder to quantify the extent to which there are damages, but if there are, that's what we work very hard to recover.
Well, you often find yourself in federal district court throughout the country. When's your next stop in federal district court?
We have cases pending now throughout the country. I've got a case pending in the Ninth Circuit, which is in California, Ninth Circuit Court of Appeals. We've got a case in the Federal Circuit Court of Appeals, which is down in Washington, D.C. That's pending. Both of those are coming up. So, we've had cases. We'll go wherever, the need brings us. We represent clients in New York State, but we represent clients really throughout the country. So we have no problem, traveling to, San Diego or Los Angeles or North Carolina. There's a lot of furniture companies and military-related clients that we have down in North Carolina. And for an upstate law firm like ours to be able to have kind of a national practice, it's really a wonderful thing. We're able to, have the kind of quality of life of upstate New York, which is wonderful, but also have a practice where we're going head-to-head against big city law firms.
Well, certainly the Capital Region Bar appreciates having your firm designated in that way, and brings so much credibility to our entire Bar Association here, and we're very fortunate in that way. You're very busy, and on top of that, family in Albany County, and children as well.
Voorheesville. We live in Voorheesville.
Well, that's fabulous, and so that will also certainly keeps you on your toes day in and day out. We're very fortunate here in the town of Colonie to have been able to have you come share some of your background and experience here on intellectual property law. And there's nobody better to tell us about that than David Miranda. And I'm so happy that you came here today to visit with us and tell us a little bit about your particular practice. How would people get a hold of you, David, if they wanted to ask you some questions directly?
Well, I'm at Heslin, Rothenberg, Farley, and Mesiti here in Albany, and my phone number is 452-5600. And
the office is out on Washington Avenue Extension.
That's correct. Washington Avenue Extension, across from the Italian Community Center near the Pine Bush.
Well, that's fabulous, and you're doing a super job on behalf of your client, Shirley, and of course, with your efforts on behalf of the Albany County Bar Association. I know all attorneys in Albany County are very fortunate to have you serve in that capacity as well.
I think because we focus exclusively on intellectual property law, that we have a good relationship with all attorneys in Albany County and elsewhere, because as long as they're not practicing intellectual property law, we're not really competitors.
Well, it's fine. You're only enhancing our capacities here in the Capital Region. Thank you for joining us today, David.
My pleasure. Thank you, Judge.
I'm Judge Peter Crummey, and thank you for joining me on Benchmark.